It's day 7 of jury deliberations in the social media addiction trial against Meta and Google. Just over an hour ago, the jury submitted its 10th question to the judge. Quote, "We, the jury, are having difficulty coming to a consensus with one defendant. Do you have any advice on how to move forward?"
For more, let's bring in Fox News contributor and criminal defense attorney Donna Rotuno, along with Kurt, the cyber guy, Kurt Knudsen. Thank you both for being here. Donna, I'll start with you. Friday night, Brian and I were sitting here. We were on standby waiting for this verdict. I know you guys were as well. And I'm thinking to myself, it's before the weekend. If this jury wants to wrap this up, this is the time to do it. And they didn't. So now we're here on Monday, and they're asking a 10th question. You heard what the question was. Your thoughts on where they are with this?
Well, I think, and I agree with you, I think we all thought that by Friday we would probably have an answer. We were all sitting around waiting to come on air if that was going to be the case. The fact that they didn't obviously shows that they thought that they had more to do and it wouldn't be something that they could determine quickly. I think the question that they asked has a lot to do with probably determining liability if they're having problems with one defendant. I mean, given the questions that we've had prior, it seems that that's the phase that they are in, is liability and or damages, and not really so much should we find them liable, right? So it's a very interesting issue that it's taken this long. I think that there's probably a few holdouts, given the fact that the judge has told them that they only need 9 for a consensus. So that means that there's probably more than 3 that are putting up a fight, right? Because if you only need 9, you know, and again, we're all reading tea leaves here to make determination as to what's going on, but the fact that this is continuing to go on, I think is probably better for the plaintiff at this point, but.
And to Donna's point, I mean, the grin on the plaintiff attorney's face on Friday really told the story. And I did speak with them privately after that, and I just said, what does all this mean? This question number 9 that came was related to if a juror, and they have to fill out, each juror has to fill out a verdict form. And on the form, it essentially says, in one case, it'll say, did Meta or Instagram harm her in such a way by the way the product was designed or operated? And then the next one is, to what degree did they prevent harm from occurring? If you believe those were true, then you go to the damages section. So it's same for YouTube. So it told us that at least they had a consensus of at least 9 people that yes, indeed, one or both of those defendants, either YouTube or Instagram with Meta, is going to get, something's coming.
They're going to be on the hook.
Yeah. They're going to be on the hook.
All or nothing harm. In some states, you can have contributory negligence. For example, you contributed a certain portion of the harm. Can you have that here and then have damages, or is this all or nothing? Yes, you harmed this person.
I think here it's all or nothing, but they're determining what those damages are, so they can have that conversation. They can say, okay, we think it's worth X, but let's take something off for maybe some of these other contributing factors that may be an issue. But in the way I looked at the verdict forms, they're just asking for a number.
Yeah, Donna picked it. When we were chatting just a bit ago, she said, I bet it's YouTube is the holdout because they're, of the 2 defendants, who harmed your child? Would it be the social media machine Instagram, or would it be YouTube with lots of videos? You would tend to believe that would be the social network part of Instagram. So I think that might be what's the holdup. I think she's onto something, and I also think that we're about to find out because the judge now, with question number 10, is sending them back and saying, you need to work this out, and you're not getting off the hook. It's an interesting language from the judge was, go do your job and answer this. No matter what, you're about to see a verdict come out of here that is going to be an earthquake around Silicon Valley. And, I mean, this is a wake-up call to a lot of people, from Mark Zuckerberg to lawmakers in Washington to parents to these platforms and how they operate. We're going to see a lot of changes almost overnight. Have you noticed, by the way, on TV, all these ads from we're Facebook, we're Instagram, we're TikTok, we're helping protect your children. It's like all these great, they're all over the place.
Yeah,
it's almost an admission of guilt, right?
Well, maybe getting ahead of something. I guess I wonder, maybe, Donna, just the length of time of the deliberations here. Even if these defendants lose, does the amount of time it took tell you that this isn't as slam dunk of a case as maybe some people thought it was going to be?
Well, I think the defendants thought it was a slam dunk of a case, or they probably wouldn't have gone to trial. They may have settled and stopped themselves from this. So I think really the length of this is probably surprising them. But you have to remember, first of all, I want to say, for the most part, I've tried hundreds of jury trials, and I think that jurors want to get it right. I do. I think once they're in that position, no one wants to do it, but once they're in that position and they're serving, they want to get it right. They take it seriously. They do try to learn. This was a very long trial. There was a lot of things to discuss and think about. So I do think that is the goal of a jury. I also think that the length of time goes to the fact that there is serious conversation and potential disagreement about what some of these things show. But remember, every single person in that jury room has a phone in their hand.
Yes.
And maybe not while they're deliberating, but they are all used to walking around in their lives living with phones. And all of us know that there is an addictive nature to these phones. So it's a different type of juror that can put themselves in the shoes of the plaintiff here. And so I think that also changes the way these deliberations go down, because they have personal experience.
Yeah, you can find somebody maybe in another case who isn't familiar with the details or hasn't read the papers.
Exactly.
But everybody's got a smartphone.
Donna Rotuno, Kurt Knutson, great to see you guys. Always appreciate having
Thank
your
you.
expertise.
Brian, Jackie, great to see you guys.
Thank you both.